wasn't pursued it, but this could have been three separate.
Okay, but it wasn't three separate. Let's go with what happened in the case.
But honey, oh my God, I'm sorry. I'm sorry. That I don't know what to say to that. I apologize.
Okay, go ahead.
The question here is what happened. I'm sorry, I've just been totally thrown by my mistake.
I can imagine. I'm a little thrown by that also, if I'm being honest.
Your Honor, I don't know what to say. It's just
Okay, well, go ahead. You've only got 1 minute and 7 seconds left.
The question here.
Bro T. Michael. You're here on a charge of driving while intoxicated as a third or more offense. Bond is set at $25,000. On that one, do you want to hire your own attorney, ask for court appointed, or wait and make that decision later?
I guess I'll wait and make that decision later. I wasn't intoxicated though.
Okay. I don't have your FBI number plugged in. Along with your charge comes an ignition interlock order. Ignition interlock device is a device that keeps you from driving. If it detects alcohol in your breath, within 24 hours of being released from jail, you'll need to get to 650 South Mayhill Road here in Denton to start the process for getting that device installed on your vehicle. While you're out on bond, you're not allowed to consume alcohol of any kind, including in your own home or at dinner. No consumption of alcohol, no illegal use or possession of any controlled substance, marijuana, or THC product. Got to get that device installed in your vehicle. Can't drive a vehicle unless it's equipped with an ignition interlock device.
I haven't had a drink in 2 years.
Yeah, your voice right now suggests that there's some intoxication going on.
I just woke up.
Both lanes, and that you were falling asleep. They saw you like dozing off behind the field sobriety.
The clip's a little messed up. That is actually not me. That's the way I got it.
The test which indicated that you had some level of intoxication.
Yeah, how is that like a
blood test too?
I got like in an argument with my girlfriend, and I was angry. I just don't understand how this is legal.
Yeah. So if it's based on like non-alcohol but prescription medication, then I mean that can be a DWI also. So it doesn't just have to be alcohol consumption. So it's anything that affects your ability to drive, mental or physical processing, and we still get behind a wheel even though we have some issues, then it could result in DWI. Got to get that device installed in vehicle though. Osorio, Eduardo?
There's another signature for you.
Oh, we're missing interlock.
Hey, there's another signature and it's ready.
Okay, how am I supposed to get a phone that works? The phone does not work at all.
We've already explained that to you. You can walk back to your cell.
All right, Osorio. There we go. All right, you're here on a charge of assault causing bodily injury to a family member. Bond is set at $1,500, relatively low bond. On that one, do you want to hire your own attorney, ask for court appointed, or wait and make that decision later?
Judge, can I make a note that the arresting officer didn't read me my Miranda rights?
They don't. So yeah, it's only if you're in custody and that they're interrogating you that they'll do Miranda.
Okay,
So as long as they didn't put you behind a on a table glass, the light, and where were you on this day, then Miranda doesn't apply. It's not like on the TV where they, as soon as they put you in handcuffs, that's just so they can close out the show in a dramatic way. On like CSI, they throw the guy in handcuffs and then they read them their rights and then the credits roll. That's just to end a show. It's not because the Constitution requires that. They add that in just for cinematic effect.
When
It's more explanation than he deserves, but okay, Judge.
the officer went to go talk to my baby moms, we had
Sure.
told them that earlier, before I had left the apartment, that we were discussing, and that she was leaning against the door and the door had pinched her.
Oh, no. Don't go into the facts yet. Your attorney won't want you to discuss that with me. They'll so wait till you get an attorney. Let the attorney know what happened. Your bond is low because I gave you benefit of the doubt on that issue. So I completely understand what's going on, but your attorney's going to be not now on the record, being recorded. You don't want any stories captured yet.
Okay, so,
If you understood your rights, it's ready for your signature.
Somewhere around $100 is what you, friend or family would pay to a bondsman to get you out the door.
150?
Yeah, somewhere around there.
Thank you, Judge.
Thank y'all.
This is case number 25L00742SM, State of Michigan versus Ronald Lewis Jones Jr.
Secretary, on behalf of the people. Tobias on behalf of Mr. Jones Jr. Did you state your name, sir? Jones Jr., Ronald Lewis Jones Jr., miss.
Okay, Mr. Jones Jr., you're here for a pretrial. This is on one count of domestic violence, a 93-day misdemeanor that carries up to a $500 fine. And of course, you have a right to have a trial on that charge. Could be by judge or by jury. You have a right to have that with your lawyer representing you. You understand that? Yes? Okay, so we've been here before. It looks like there was no attorney assigned at that time. So now we do have your lawyer assigned. So have you had a chance to get your discovery now? Okay, so you'd like adjournment for that?
Yes.
Okay.
Next week, perhaps.
All right. So we'll need an adjourn date a couple weeks.
Court's available August 25th at 9 a.m.
That works for me.
All right, 9:25. 8:25, excuse me. 8:25.
Okay, this one's Alyssa's fault. The last one was Brecken's fault. The introduction was Beth Leary's fault. They're all good. This guy's a vibe. I mean, clearly he's not all there. She's very gentle with him. It's kind of charming.
25 at 9. Fine, let's continue.
There you go.
Okay.
Yeah, come back. Gotta go back home run. Oh. Come back, Mr. Jones.
What happened?
Did you inform Mr. Jones of the double contact order?
Okay, I'm off this case. Hold on. Mr. Come on. Yeah, okay, Mr.
Guys from right there.
Is this okay? He just.
I don't know why I'm here for. I've been here for. I want to go back home, play with my jewelry and stuff, drink coffee, smoke cigarettes.
Okay. Well, apparently.
I can go back home. I can't.
He just wants to go home and smoke cigarettes. This guy is straight sling blade. That's who it is. He kind of knows. He knows what he's having a nicotine fit. Is what's going on.
I can't wear my stuff. There's too many murderers there.
Where's Mr. Jones's file? File, not father. Okay, Mr. Jones, your lawyer wanted me to remind you of the conditions of your bond. Okay, so right now, the way it stands, you're on a personal bond, meaning that you're out walking around. You didn't have to put up any money, anything like that. We just need you to do a couple of things. And one of the things we need you to do is not to have any contact with Mr. Ron Jones Sr.
Good.
Okay. And let me tell you something. There's a court order saying that you don't
I'm not gonna do nothing stupid. I'm not a demon.
Okay, but you still can't be around him until the case is over.
Case is over.
The case is not over yet.
Want to be over.
Well, we're coming back after your lawyer gets.
I have to go to my own house tonight.
Okay, let me tell you something. You got to be patient. Let the process work the way the process is working.
Wait.
Okay, your lawyer needs to get the police report and other information so he could get an understanding of what the prosecution is claiming happened. Then he can talk it over with you and decide how to defend this case. While this is all pending, we don't really know what happened. So that's why we have to keep you apart from the people that were involved in this thing. Until
It's
until, well, the case isn't over. Maybe the conflict that you may have had might be over.
People at the group home talk to me, the workers at the group home talk to me, the place where I go to meet the people, they talk to me, they say, don't do that, it's over, it's a done deal. I'm out of here.
Charles, sir. Charles, go get him. Apparently so. All right, so we're back here after a brief bench conference in this matter. So my understanding, Mr. Starr, is that there's additional information that you thought about and you'd like to request something?
No, I think it's prudent here to forensic evaluation. Spoke to Mr. Jones Jr.'s mother and his sister, and they said they can take him there, when that date comes up, and maybe why just for the sake to get him there, the no contact order. Well, his mother could still have the no return to that address. And I believe his mother is okay with this no contact order.
Okay. That's Miss Brenda Jones?
Yeah, she's in the court.
All right, well, Miss Jones needs to understand that she will be able to talk to her son and be around him, but she can't bring him to the house, nor can she bring him around Mr. Jones Sr. There's still a no contact order in force as to Mr. Jones Sr. So yeah, she can talk to him, she can call him, she can go visit him, she can take him wherever he needs to go. She just can't bring him home.
Why can't I go home?
Because, sir, there's a no contact order with Mr. Jones Sr., and that's where he lives. So you can't go there right now. It's not.
I don't have no beef with them.
It's not permanent. So you're going to have to be patient. It's just for right now.
For how long though?
And we're going to see. And your sister.
The poor thing, he literally doesn't understand. He's not even playing dumb. He literally doesn't understand that he can't go home.
And or your mother are going to take you up to the forensic center, and they're going to.
What's that for?
Well, they're going to just do a little evaluation. So
I need too much evaluation.
Well, we need to have it because when it's raised in a courtroom, we have to make sure you understand the nature and all of the information about charges that are pending before you, and that you're able to adequately help prepare your defense with your lawyer.
Well, I have to do all that?
Well, yes, you do. We have to make sure you're able to do that. And then
I don't want to go to the forensic center.
No, it's not. It's just for an hour or two.
Right now?
Not right now. They're going to tell you when they're ready, and your mother and sister are going to take you there. It'll be an hour or two, then they're going to bring you back. You're not going to be staying there.
What is forensic? I don't get into this police business. I don't watch TV at all. My brain races. I don't watch TV at the group. I just use my phone. I never did watch TV since the 90s.
Okay, that's okay. You don't have to watch TV.
What is forensic?
Okay, well, that means that they have doctors there, and they're psychologists and clinical psychologists.
I seen my doctor a month ago.
Well, sir, we cannot proceed with this case until you go to see these people.
I saw my doctor.
Because we don't know exactly if you're able to help your lawyer prepare the case, and if you understand the nature of the charges and everything that's against you. Sir, whenever it's raised, I do have to do that. Yes, I do.
Do I have to do that?
Yes, you do. You got to do it for me, okay? Yeah. It'll be okay. It's not going to take that long.
Do it for me.
Sir, your mom will talk to you about it later. She's going to take you, okay? It's going to be okay. It's nothing bad, and it's not going to take that long. And we have to have it done for this case. So just calm down. It's okay. And just go for me, okay?
Get that right there. I'm not a devil. I like a wayne.
Nobody said you, sir. No one has said.
Guys, whatever happens.
No one has said you were a devil.
I'm not a demon. Yeah, like I be around, so I'm in the street, man. And it's not like Southfield. And it's gun and it's weapons over it, and it's dogs over it. And I seen them, and that was too. I seen them all on 2 eyes. So I stay out the way, and I talk to guys. They talk to me too.
That's good.
I'm not a demon.
You continue to stay out of the way of trouble.
No, I'm not a demon.
I don't think you are.
No, I'm not a bad guy. Anybody say you a good guy, you need to go home, Jones. You need to go home. Everybody at the group home tell me that. You need to go home, Jones. You need to go home.
Well, there'll be a possibility of that happening down the road.
Then
It's
when?
not today. I have to wait till you get the evaluation at the forensic center. Then I can tell you more. Okay. All right. So, do we need to change? You still want to come back on August 25th because he will not have had his evaluation by then.
Yeah, we need to stay in order, so I don't.
Mr. Salke, Mr. Salke, Mr. Grant, you guys kind of favor with it. Mr. Grant, could prepare the order for me.
I don't think it's necessary.
Right. That's what I'm saying. You might want to cancel August 25th.
Yeah.
And get a later date
Yeah.
to see if we can have a report. So let's get like a 90-day review on this. For forensic.
Close back in that house. I remember all that night. Rain down.
Court's available November 24th at 9 a.m.
Okay. November 24th at 9. That is our review date. Of course, if we get a date sooner than that, we will contact both counsel and we'll move it up. Okay. So he'll sign his, Charles, you're going to have to change them. And he'll sign the new notice and he's all set. And the forensic center's going to let you know and you can let his mom know. Okay. That concludes this matter.
Position number 19, Mr. Moore.
Okay, this is from today, I think out of Atlanta. This guy is not charming. This is a nightmare. This is an absolute nightmare. This is horrible. Don't watch it.
Mr. Moore, your case is 25 CR 004590E. You are charged with interference with custody. Do you understand your rights today?
Yes, ma'am.
All right. Mr. Howard?
15. On probation, possession of marijuana with intent. On probation for hijacking motor vehicle, ag assault, battery. 2025 fade to appear. He got some battery DV charges, convictions from the past. And I know his booking says CPO returned to Hall County. That's it.
Okay. Miss Falk?
Yes, Your Honor. Pardon me, Mr. Howard. What does the CPO mean?
Court production order.
Ah, okay. Thank you. I'm just not as familiar with that. I appreciate that. Okay. So, Your Honor, the 22 SC 183968 case where the defendant, the hijacking a motor vehicle, aggravated assault, family violence battery, that was pled down from a hijacking to a criminal trespass, and the family violence batteries were kept and made consecutive. The aggravated assault was reduced to a family violence battery, and that involved Miss Justice Williams, and the defendant is still on probation. He was just sentenced June 23rd of 2025 on that case. In this case, Your Honor, officers spoke with Miss Demi Tomlin on July 6, 2025. She stated that she had a court order from June 3rd, 2025, where Judge Benton had granted her sole custody of her son, ZT, who was at the time of this incident 8 years of age. The defendant refused to comply with the order, refused to grant access to her son, and had been hiding her son from her since October of 2024. She also stated that he was leaving her child with people she did not know. She finally, after getting that court order on June 3rd, got the defendant to agree to meet her at his barber shop so she could pick up her son. She waited for 2 hours. The defendant never showed up. And at that point, she called the police and made a police report regarding the fact that her son was essentially not being returned to her. I will say that my real concern here, and when they finally did speak to the defendant on July 4th of 2025, he was in the Hall County Jail, and he advised the officers that ZT was in Philadelphia, Pennsylvania with his grandmother. And so at that point, he was told that he needs to make arrangements to return his son back to the state of Georgia and back to the lawful custody of the mother, Ms. Tomlin. The state is really concerned in regards to this case, Your Honor. This is essentially, this man took his son, took him away from his mother out of the state for over 8 months. And this mom had to go get a court order. And even after getting a court order, he still refused to comply. I mean, essentially, he's basically kidnapping his own son away from his lawful guardian.
Yeah, he sure is. I didn't like it when Sarah Pike Levy did it. And I don't like it any better when this jerk off does it. You can imagine an 8-year-old, you take an 8-year-old for 8 months. She's got custody. She's got a court order. He doesn't have custody. And then he gets thrown in jail and he lies to the police and says, the kid's out of state. So where the hell is the kid staying? Somebody who's friends with him and he's just a straight criminal. Hey, it's a nightmare.
For that reason, we are asking for a $10,000 surety bond. We are asking for no further contact with ZT, no further contact with Miss Demi Tomlin, and stay away from them absolutely unless he has a court order saying otherwise. No alcohol, drugs, or weapons. And again, Your Honor, I do want to point out with his history of family violence, which he is still under sentence for currently, and his other history, we do have concerns about a risk of reoffense here and him possibly taking the child out of state again. That's all for the state. We would like to sound for Miss Demi Tomlin.
Okay. And the allegation, Ms. Funk, is that he has no custodial rights at all?
That is correct, Your Honor. Judge Alice Benton granted Demi Tomlin, I think, sole legal custody of her son. It says below she was granted sole custody of her son.
It's legal and physical.
No, don't start talking yet, Ms. Tomlin. Hold on. I'm sorry.
So
Ms.
it sounds like it was both sole legal and physical custody of her son.
Okay. All right. Ms. Tomlin, I'm going to let you make a brief statement. Please raise your right hand, but I'm going to give you some instructions. Whether you disagree with what Ms. Falk has to say today or how she presented the case, that's not what I'm most concerned with. I'm most concerned with today concerns for your safety and whether you wish to have any contact with the defendant. This is a bond hearing and there will be other proceedings whereby the facts will be fleshed out, okay? Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes.
All right. What would you like to tell me today?
I just want it to be known to the court that this custody battle started in 2021. We were in Judge Farmer's chambers, and unfortunately, the case was ignored. We filed over 10 contempt motions. He refused the past 4 years to abide by any court order. He has threatened me, if you try to go to our son's school, you're going to go to jail. I'm the one who's in control, even though we had 50-50 with the right of refusal before I was granted sole custody. He walked into court 20 minutes late, as our order that's already in Fulton County Superior Court states. He thinks he's above the law because, as you heard, all of his charges always get minimized. He's done this to other women, not just me. And he also... still now, the woman who actually brought my son to the police station on this last occurrence, I actually had to get a TPO on her because she put a tracker in our son's bag and has been stalking me, sending mail to my house. So this is ongoing. He, even from jail, he lied to the officers, told them my son was in Philly, and even still from jail has somebody harassing me. And it's not okay. He does not care that he owes me child support, but he went and he retained an attorney for his last case in Hall County the other day. It's just, he doesn't care that what he's doing, the toll it takes on my mental health. I have to be a parent not only to our child, but a 13-year-old and a 3-year-old as well. I have 3 children, not just ours. And he doesn't understand what all of his actions are causing in my life, which is very hard to be a parent without all these issues. All of this is
he doesn't understand it and he doesn't care. And that was his character when you met him. Let's be honest. But other than that, I do feel sorry for you.
Necessary. I shouldn't even be having to do this. I went to court rightfully. And he didn't abide by that. If he won't abide by y'all order, who am I? I'm nobody to him, clearly.
All right, so I'm assuming you don't want him to contact you at all.
Absolutely not.
Okay.
No, never.
All right. I appreciate you coming to court and making that statement, Ms. Tomlin. Thank you. Ms.
Your Honor,
Rosen.
just really briefly, I do apologize. The warrant at the very, very bottom does say that the child was not out of state. He did lie to the officers and the child was actually in town with another individual.
All right. Thank you. Ms. Rosenhuber.
Thank you, Judge. Mr. Moore is 33 years old. He has resided here in Georgia since he was 12 years old. He did earn his bachelor's degree from the University of Kansas, and he also obtained his associate's degree. As the court heard, he does have a barber shop that he owns and operates here in Buckhead. And Judge, he is going to be in Hall County custody, it's my understanding, until at least November. He doesn't have the resources with which to post a bond. Judge, we would ask for a reasonable bond given the circumstances. Thank you.
All right. Defendant's going to receive a $3,000 surety bond. He's to have no contact with the alleged victim or the minor child unless he has the parenting documentation that indicates that he can do so. He's to have no alcohol, drugs, or weapons, and he will be reset to all purpose on the 21st. Is there anything additional?
Just to stay away from her residence or workplace.
All right. We can abide by that. Stay away. All right.
Thank you, Your Honor.
All right. Best of luck to all parties concerned in this case. That concludes your case for today, Mr. Moore. Who do we have next?
On the record in the matter of the state of Michigan versus Dean Davis, 25-02389.
I didn't plan this, but this whole stream is men just not doing well. But I did give the ladies their own stream last night on Vlog Talk with Mike with a complete update of the WNBA. If you haven't seen it, it's spectacular.
Good afternoon, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Assistant Public Defender Joseph Hardy on behalf of Mr. Davis.
This is Dean Davis Jr., is that correct?
Yes.
Okay, Mr. Davis, I do have a felony complaint here that you need to be arraigned on. The allegations are that on or about August 5th, 2025, at the area of 517 North Sycamore Street, which is in the city of Lansing, Ingham County, state of Michigan, that you did allegedly in count 1 commit the act of unlawful imprisonment. The allegations is that you did knowingly restrain an Austin Takami Iwahara by means of a weapon or dangerous instrument, and or knowingly restrain Austin Iwahara to facilitate the commission of assault with intent to do great bodily harm, interfering with a crime report, committing a crime, threatening to kill or injure, or interfering with electronic communications, a felony, and or secretly confined and knowingly restrained Austin Iwahara contrary to MCL 750.349B. There's a Sex Offender Registration Act notice indicating that this is a Tier 1 offense under the Sex Offender Registration Act if the victim is a minor. It's a Tier 2 offense if the defendant has a prior conviction for a Tier 1 offense. It's a Tier 3 offense if the defendant has a prior conviction for a Tier 2 offense. Count 1 is a felony. The maximum penalty is 15 years in prison and or $20,000 in fines. Count 2, assault with intent to do great bodily harm less than murder or by strangulation, alleges that on or about August 5th at 517 North Sycamore, that you did make an assault upon an Austin, Iowa horror with the intent to do great bodily harm less than murder, and this is contrary to MCL 750.84. That's a felony. The maximum penalty is 10 years in prison or $5,000 in fines. Your DNA is to be taken upon arrest. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. Count 3, interfering with a crime report, committing a crime threatening to kill, injure, or cause property damage, alleges that on or about August 5th, again at 517 North Sycamore, that you did, through the unlawful use of physical force, prevent or attempt to prevent another person from reporting a crime committed or attempted by another person. And the violation involved committing or attempting to commit unlawful imprisonment or interfering with electronic communications or threatening to kill or injure a person, contrary to MCL 750.4831 and MCL 750.483A2B. That's a felony, maximum penalty, 10 years in prison and or $20,000 in fines. A consecutive sentence may be imposed for any other crime, including any violation of law arising out of the same transaction. Count 4, interfering with electronic communications, alleges that on or about August 5th at 517 North Sycamore Street in Lansing, Michigan, that you did willfully and maliciously prevent, obstruct, or delay by any means the sending, conveyance, or delivery of an authorized communication by or through a telephone line, and that this was contrary to MCL 750.5405A. That's a felony. Maximum penalty, 2 years and or $1,000 in fines. Count 5, child abuse, 4th degree, alleges that on or about August 5th at 517. Are you falling asleep, sir?
Not falling asleep, just confused. I don't understand how half these charges or any of these charges, I'm going to need a lawyer for sure, because it's, how did I prevent anyone from doing anything when she willfully called the cops on me? So I just don't understand any of that. She willfully left the apartment. She willfully did anything. How did I prevent anything if she just did those things? She did those things, you know what I mean? Let alone child abuse. We have a child together. How did I abuse the child?
Exactly. I'm sorry, Mr. Hardy, are you representing him today?
Yes, Your Honor. I was able to get an intake done earlier today.
Oh, I'm not used to attorneys allowing their clients just to freely talk, so I'm not going to stop.
You asked me a question. I'm not falling asleep. That's what's going on.
I asked you, were you falling asleep? I didn't ask you to say anything about the facts of the case.
I'm not falling asleep. I'm just confused on how I'm being charged with things that I didn't do.
Okay. That's count 5, child abuse, 4th degree, that you did knowingly or intentionally commit the following act or acts under the circumstances which posed an unreasonable risk of harm or physical injury to a child by attacking the mother holding that child. Now, this is contrary to MCL 750.136B78. That's a misdemeanor, maximum penalty 1 year or probation for up to 5 years. Count 6 is domestic violence, alleging that you did make an assault and battery upon an Austin, Iowa, an individual with whom you have a child in common or a resident or former resident of your household, or an individual with whom you had a dating relationship, and that this was in violation of MCL 750.812. That's a misdemeanor. Maximum penalty is 93 days in jail and or $500 in fines, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. There is an habitual offender, 4th offense notice, says take notice that the defendant was previously convicted of 3 or more felonies or attempts to commit felonies, and that on or about September 20th, 2021, he was convicted of the offense of possession of cocaine in violation of 893.13.6A in the 1st District Court of Suwannee County in the state of Florida. And that on or about September 20th, 2021, he was convicted of the offense of possession of LSD in violation of 893.13 in the 1st District Court for Suwannee County in the state of Florida. And that on or about September 6, 2016. He was convicted of the offense of police officer resist in violation of 843.02 in the 4th District Court for Palm Beach County in the state of Florida, and therefore the defendant is subject to the penalties provided by MCL 769.12. The maximum penalty you're facing is life in prison if the primary offense has a penalty of 5 years or more. The primary offense in this case does have a maximum penalty of 5 years or more, so you are facing up to life in prison. Do you understand that?
Yes, that's ridiculous. If I get life, that's unbelievable.
I didn't ask for you how you felt about it. I asked if you understand the maximum penalty. Okay?
Yeah, I understand it.
I also have file number 25-01864. Let's see here. It looks like that's a domestic violence file that you have pending before Judge Buchanan with the same victim, which means, and I see here that there was a no contact order in place, that you have a final pretrial on August 11th and a jury trial on September 8th. So there's a bond violation pending on that file because you were not to be in contact directly or indirectly with an Austin IOR during the pendency of the domestic violence case. You also were not to commit any crimes or pick up any new charges. So that matter will be set for a hearing before Judge Buchanan on the bond violation, and the court will enter a not guilty plea on your behalf. You have the right to remain silent. Anything that you say, anything you put in writing can be used against you. You have the right to plead guilty. You can plead not guilty, or you can stand mute. I'm going to repeat. Anything that you say on this record can be used against you.
You know, if he exercised that right to remain silent, we wouldn't be here, right?
And so you have the right in this file, the new felony file, to proceed to a preliminary examination. You have the right to have that preliminary examination within 21 days of today's date, unless the court finds good cause to go beyond that 21 days or you waive the 21 days. You're currently scheduled for probable cause conference before Judge Stacia Buchanan on August 15th at 9 o'clock in the morning. You have a preliminary examination before Judge Buchanan in person at the court August 22nd, also at 10 a.m. Did you get a notice to appear?
No.
You did not get a notice to appear?
Oh, they just gave it. I guess I haven't had a chance to look at it. They gave it to me 2 seconds before I was called up here.
Okay, and where did you put it? In your pocket?
It's in my hands.
Can you see it? Make sure you have the correct dates on there.
Friday the 15th, Friday the 22nd.
Very good. Okay, you have the right at the time of your preliminary examination to require the prosecutor establish sufficient probable cause that a felony was committed and probable cause sufficient to charge you with the felony. You have the right to take this matter to trial and the right to maintain your innocence until proven guilty. You have the right to require the prosecutor prove each element of each of the charges being brought against you beyond a reasonable doubt. You have the right to maintain your silence at trial, and that can't be used to prove or imply that you're guilty. You have the right to question or cross-examine in court any of the witnesses called to testify against you, the right to call your own witnesses or present evidence that you believe show a defense to the charge being brought against you. Do you have any questions about those rights?
Yeah, I do not want to waive my right to a speedy trial. I do not want to waive my right to a speedy trial.
We didn't say that you waived your right to speedy trial. We know that you will not waive your right to that, sir.
I do not want to waive my right to speedy trial under any circumstances.
But that was not my question. That was not my question. My question is, did you have any questions about any of the rights that I just went over?
No, ma'am.
Okay. What is your address? Is that the address of the protected party?
Yeah, I have another address as well that I can stay at besides there.
Well, obviously, because you already have a domestic violence, so you can't stay with her, and you know that.
I know, she stays at my place. That's my apartment. She stays there. That's fine. Okay. I go to my dad's place.
What's your phone number? Are you on probation or on parole?
No. I would just like to say being held against her will, though. I went to the hospital.
Sir. Please stop.
That was the day before. And then the day that I got arrested the next day, she just left. Like, at no point did I have her phone, stop her from doing anything. Like, to say that I held her against her will is just ridiculous. Or took her telecommunication device. It's just ridiculous.
Please stop talking.
Okay. I'm just saying, there's plenty of evidence that would prove I didn't do that. She left the house multiple times before she came to the decision that she was going to call the police because I didn't want to reconcile with her.
Counsel, you can address bond.
Thank you, Your Honor. So, Mr. Davis, we do acknowledge the seriousness of the charges. What I would say is that he is someone that has lived in Michigan his entire life. He does have another separate place to stay to keep him away from the alleged victim with the address that he just gave. I would say that according to what he stated to me, is that he does not have a history of failing to appear either. So I don't think there's any danger of him attempting to flee this court's jurisdiction. I do think that these are that with these allegations that any concern for the public could be alleviated through the use of a GPS tether. So I'd be requesting a low 10% bond, Your Honor.
The prosecutor here to be heard on bond.
Yes, Your Honor. First, it appears that he's been misleading his attorney. He's absolutely been charged with failing to appear in prior domestic violence felony cases.
Tell my attorney. I told my attorney that I had not appeared before.
He has
not the one
not
misleading my attorney.
Sir,
I did not mislead my attorney. My attorney forgot what I had said.
Mr. Davis.
My attorney forgot what I had said.
Mr. Davis, you have one more outburst and you are remanded, and we won't address your bond. Close your mouth. Close your mouth.
Inconsistencies all through here.
Remand. Bond denied.
Thank you, Your Honor.
Thank you, Your Honor.
Have a good rest of your day.
Same to you.
Well, there you have it. I thought we'd end on a high note. That was Alyssa's fault. I was watching it. I'm like, what? Why are we watching this thing? But I will have to say it closed strong. Dude, you just can't shut your mouth. You can't shut your mouth. He might have been able to get out on bond with the tether, but he can't shut his hole. Good times. All right. That's it. Everyone, behave yourselves. I'm not bailing you out.